On July 22, 2016, Officer Robert Massey of the Tucson Police Department approached two individuals on a median strip in Tucson, Arizona, while investigating reports of domestic violence or underage drinking. After Officer Massey and his partner arrived on the scene, they encountered Basilea Mena and a companion on the median, where Ms. Mena reportedly inquired about the officer's presence and refused to provide identification as requested. During the subsequent arrest, Officer Massey physically forced Ms. Mena forward while attempting to apply handcuffs, causing her to strike a palm tree. This impact resulted in cuts and scratches to her forehead and shoulders, for which she later sought medical attention. The initial case, which involved claims of excessive force brought under 42 U.S.C. 1983, was heard in the U.S. District Court for the District of Arizona. There, the judge denied Officer Massey's motion for summary judgment based on qualified immunity, ruling that a jury could find the use of force excessive. Officer Massey subsequently appealed the decision to the Ninth Circuit, arguing that his conduct did not violate clearly established law, and that the level of force used was a reasonable response to the circumstances and safety concerns on a busy roadway. The appeal was set for oral argument on January 22, 2020, before Judge William Fletcher, Judge Ryan Nelson, and Judge Donald Malloy. Officer Massey was represented by attorney Dennis McLaughlin, and Ms. Mena was represented by attorney Damian Gallagher. Because Officer Massey initiated the appeal, Mr. McLaughlin had the opportunity to present his oral argument first.
Qualified immunity case. Your Honors are well aware of the standard, two-pronged standard. There needs to have been a constitutional violation, and it needs to be clearly established in law at the time that the events occurred. Neither of those have been met here. This case is 2.5 years old, and the plaintiffs have never brought any case forward that actually makes clear that that this would have been a violation for what the officer did.
Can you tell me what level of specificity is required to meet that prong? Does it have to be a case that says, hypothetically, slamming a woman's face into a palm tree is a violation of the Constitution, but if the next case is slamming the face into a pine tree, do you have to have a pine tree case? What is the level of specificity?
Your Honor, what I understand the level of specificity to be is you don't have to have clear, all that the Supreme Court has said is you don't have to have clear precedent that's exactly on point, but it has to be reasonably clear, I would say more than reasonably clear, to a reasonable officer that what he or she is doing is wrong. And we do not have that in this case. Oh, I understand your concern. We do not have that in this case. We have a situation where a woman is in the median, she's intoxicated, she's antagonistic, she's uncooperative, she won't move away from the person she's with, which means that, and she won't give identification. So the officers can't investigate anything of what they are suspecting. Moreover,
what were they suspecting? It's unclear to me.
Either possibly domestic violence, Your Honor, or underage drinking. And
how old was she? I didn't even.
If you look at the pictures, which I think are ER 39,
the ones with the big gashes on her head.
Yes. Yeah. She's 22. I believe she's 22 at the time. But she's one of those lucky people that it's hard to tell how old she is, whether she's younger or older.
But it sounds as though in this instance, under your argument, she's not lucky at all, because you're using that against her.
That's true, Your Honor, but that's right. But the point is the officers don't know when they're investigating whether she's underage, and that's one of the things they're looking for. I do want to emphasize, Your Honor.
I don't think there's any serious dispute that they had some ground for the arrest. I mean, just the refusal, or I mean, I don't think that's part of the fight.
Right, or detention. The court actually found that there was reasonable grounds for the detention, and there's been no appeal.
Right.
So now, what does the officer do? It's a median of one of Tucson's busiest streets. There's traffic going by both ways. He's got to think about her. He's got to think about the safety of the officers. He's got to think about the safety of the public. So what does he do? Well, one of the reasonable things that he can do is, and probably we argue the best thing he can do, is take physical control of her and get her off that median.
Of course. But according to her evidence, one of the things he does is shove her face into the bark of the palm tree. That's not getting her under control and getting her off the median. That's something distinct. So her evidence is he deliberately pushed me into the palm tree and caused me injury. So that's what you've got to contend with.
Right. So obviously, Your Honor, we don't agree with that, but you're dealing with what she's alleging.
Well, no, it's her statement. It's her evidence.
Right. What she does, she talks about being pushed or shoved into the palm tree by his body weight. E-104, her deposition at 28, lines 24 and 25. It's not, I just want to make sure we're on the same page of this is not a shove like I'm going to shove you into this tree. He is trying to get handcuffs on her, and he's pushing her forward, and that's how she's ending up into the tree. And her head is going, she also says her head is going between the tree, and she's getting scratched on her face and her shoulders.
Everything you're saying, though, may be true, but it sounds like you're making a jury argument right now. That's the concern that I have.
The problem with that, Your Honor, is if you go to the second prong, there's nothing in the law that says that what he did is wrong.
Well, I'm not sure about that. The law says you can't use excessive force. And I mean, maybe I'm viewing this way too...
In particular circumstances, excuse me.
Well, right. Well, I think excessive force is defined differently in particular circumstances,
Yes.
but it's clear you can't use excessive force. And so the question here is, when you're arresting someone, how much force is excessive? And maybe I'm looking at this too simple, but when somebody ends up with a big gash on their forehead and on their arm, it suggests that the force might have been excessive, or at least enough that you can, go to a jury.
Mr. McLaughlin argued that Ms. Mina failed the two-prong test for qualified immunity, as the officer's conduct did not violate a clearly established Fourth Amendment right, defined with the requisite specificity. While the court questioned the level of specificity required, the defense maintains that under the Graham v. Connor reasonableness standard, the volatile environment, an intoxicated antagonistic individual in a busy highway, justified the application of force. Furthermore, the defense contends that the injury was an incidental result of attempting to do a lawful detention under Arizona Revised Statute 13409, rather than an intentional use of excessive force. However, the court noted that the presence of big gashes creates a genuine dispute of material fact, requiring the case to proceed to a jury to weigh the conflicting evidence regarding the proportionality of the force used.
She's at the palm tree. We didn't put her at the palm tree. And when he goes to handcuff her, that's where she ends up being, is this palm tree. It's not like, and what he's interested in is handcuffing her and getting her under control.
Yeah, but the thousands, hundreds of thousands perhaps, of handcuffings take place without ending up with this kind of injury.
Well, it's where she was.
I would dare say that there's a lot of handcuffs that take place near palm trees that still don't end up with medical attention necessary.
Well, Your Honor, the fact is she started with Tellez leaning against the palm tree, and she's standing next to him. And she's non-compliant and arguing with the officers, not giving ID, and she's on a median. And he has to make this split-second decision, basically, of what he's going to do. And what he does is says, I'm going to get you under control physically. I'm going to take you physically and get you handcuffed. And it's minimal force. It's body weight and handcuffs under the Luchtel case, and, Your Honor, the Cheney case that I cited in supplemental authority. There's no batons, there's no tasers, there's no knee strikes, there's no pepper spray, there's no kicks, there's no punches. There's none of that.
Why not try the case? Because how does the level of specificity get established in the absence of trials? There are obviously fact questions here. You have one version, she has one version. Why not try the case and let the jury decide under appropriate instructions?
Because under the second prong, there's nothing that says that what he did was unconstitutional.
Well, I think Judge Nelson pointed out there's lots of case law on excessive force.
There is, but there's none of them that are that specific to this situation. And
Well, I sort of disagree on that because I think, I mean, the principle, and by the way, I'm very sensitive to your arguments as a general matter.
I understand, Your Honor.
But
That's why
it-
we're here.
Yeah, but it seems to me that excessive force, when you're handcuffing someone, at least my understanding of it, and again, this, I may be off base. I mean, but my understanding of it is that when they complain about excessive force in handcuffing, usually what's required by the courts is to show some sort of medical attention necessary. And that's how you distinguish between, true just made up claims. Because I'm sure that handcuffing someone is uncomfortable, detaining someone is uncomfortable. But when it reaches the level where you need medical attention, that is, to me, where that line is, where there's at least a body of law that makes it clearly established that this, at least arguably, is excessive force. Now, you may well win before a jury. I mean, I don't know all the details of how much she was resisting and things like that, but it seems to me that when there's medical attention required, that's where the line is. Disabuse me of my notion.
There was the only medical attention that was required here, Your Honor, was one visit where she got some, I believe, some topical ointments. There was nothing else that she did.
Oh yeah, but I mean, you've seen the pictures. I mean,
I would also point out, Your Honor, that under Luchtel, the fact that there's injury doesn't mean it's excessive force. That is not a proper logical analysis, according to Judge Gould in that case.
okay.
Judge Nelson challenged the defense regarding the statistical rarity of severe injuries during routine handcuffing, noting that most of such encounters occur safely. Mr. McLaughlin argued that under the Graham versus Connor standard, the officer was forced to make a split-second decision in a tense, uncertain, and rapidly evolving environment on a busy highway. Mr. McLaughlin characterized the application of body weight as de minimis force, distinguishing it from the use of intermediate weapons like tasers or batons. However, Judge Nelson explored whether the severity of the injury, requiring medical attention, serves as an objective proxy for unreasonableness under the Fourth Amendment. Relying on Luchtel versus Hageman, the defense maintained that the physical outcome of an encounter does not dictate its legality. Mr. McLaughlin argued that because there is no clearly established law prohibiting the use of body weight to secure a non-compliant suspect in a high-traffic area, Officer Massey is entitled to qualified immunity regardless of the injury sustained.
May it please the Court. Good morning. My name is Damian Gallagher, and I'm here for Ms. Mina, the appellee. I'd like to start at the point that Judge Malloy noted that this case is coming down to whether it's a pine tree or a palm tree, and that simply is not the law within the Supreme Court nor this circuit, as it was clearly established in 2016, as it is today, that an officer may not employ non-trivial force against an individual who is not resisting arrest nor passively resisting arrest.
So how do we determine whether it's non-trivial force? Can we look to the injuries? Is that determinative or is it not determinative?
Your Honor, in evaluating whether or not the force is trivial or non-trivial, it of course is a reasonableness inquiry under the Fourth Amendment, but typically in the excessive force context, it's evaluating whether or not that force was necessary and the degree of that force was necessary in effectuating that arrest. And here it was non-trivial because Officer Massey had Ms. Mina within his custody when he was handcuffing her, and once he pinched his hands in the handcuffing, that's when he retaliated against her by thrusting or shoving or whichever verb this court chooses to adopt, and threw her into a tree where, as this court has noted, she was bleeding and had scrapes on her face and shoulders.
Well, how do you establish the level of specificity? And I refer to my colleague's concurrence in the Green case, talking about the U.S. Supreme Court articulating that it can't be at a level of generality, but it doesn't have to be a case directly on point. How do you balance those things? And so we can figure out whether or not there is qualified immunity.
Your Honor, this court in Ostalinsky, as well as the Supreme Court in Anderson, has noted that a law is clearly established when a reasonable officer would understand the contours of the alleged misconduct and would know that the action would violate those contours. And here, we have defined this at a level of specificity, that an officer may not employ non-trivial force against an individual who is not passively resisting arrest. This court has made that clear in Gravelib-Blondin, and if I may, Your Honor, this court has stated though these cases do not concern tasers, they need not. Citing Diorle, it does not matter, and that no case of this court directly addresses the use of that particular weapon. We have held that an officer is not entitled to qualified immunity on the grounds that the law is not clearly established every time a novel method is used to inflict injury. And in Grave LeBlondin and Meredith, whether it's a taser or whether it's handcuffing, this court has focused on the degree and necessity of that force, not the particular weapon. And additionally, this court has focused that in Mendoza that the very act in question does not have to be previously established. Again, relying on the legal principles and the holdings from this court, not the particular weapon.
No, the excessive force cases we're accustomed to seeing, they're almost all gunshots. I've never seen a case, an excessive force case, where the injuries were so minor. Are there any other cases of which you're aware where the excessive force resulted in injuries of this sort? I don't want to put them aside in the sense that there's no injury. There was clearly injury. We see the photographs and so on. But are there other excessive force cases in which the injuries were of this sort?
Yes, Your Honor. And in Meredith, that was a tight handcuffing case, and there the injuries were scratches on one's hand, on the wrist, I believe, and almost similar to the ones in the case at bar. Although it does seem that the injuries that Ms. Mina suffered were rather bloody and uncomfortable, but it's also worth noting to stress that her injuries are not only physical, but they're also emotional and psychological damage as a result of this incident.
Well, but is there any case law that suggests we can consider the emotional and psychological damages?
Your Honor, I don't believe, within my knowledge of this circuit, addressing that on appeal. But the inquiry into whether or not the Fourth Amendment right was violated has not focused on the resulting injury, but rather the violation itself and whether or not the officer's conduct violated that Fourth Amendment inquiry. And this court has approached that with a balancing approach in Miller v. Clark County by identifying first the intrusion onto the Fourth Amendment right and balancing that against the government's important interest. And here it is, of course, our position that when Officer Massey employed this push, shove, thrust of Ms. Mina into the tree, that any government interest that they attempt to rely on under the Graham factors, whether it's the severity of the crime, whether it's a concern for her safety, all weigh in favor of Ms. Mina, given the fact that, Your Honor, she was charged with Arizona Statute 1324-12A for failing to provide her name. And counsel for appellant even admitted, and as well in briefing, that Officer Massey only asked for her ID, but then admitted that she did not provide the ID, but the law doesn't require physical ID.
Does the nature of the offense have any corresponding relation to this? Meaning, if they had a reasonable suspicion that she had drugs on her or a weapon on her, would that change the analysis? Here it's just failure to show ID, as you mentioned. Does that change the analysis here on the excessive force that could be used?
Your Honor, it could, because it is a factor, and it is a factor to be considered. However, this court, in cases of misdemeanors, obstruction to justice, domestic violence, and even certainly in this case, with failing to provide one's legal name, has hardly warranted the need for force because the offenses are minor and because these offenses are not violent. In the Meredith case, as I mentioned before, Your Honors, that was they were investigating tax fraud, I believe, which this court classified as nonviolent. And so, yes, Your Honor, it could be a factor, but because here, at most, it is a misdemeanor. But one, we do believe that Ms. Mina didn't violate this law, and Officer Massey in his deposition admitted that he never asked her for her name, he only asked for her ID, and therefore not even violating the law. And so to the extent that Officer Massey used force that was not necessary, this force was non-trivial and violated Ms. Mina's constitutional right. And because this was clearly established in 2016, as it is today, we respectfully ask this court to affirm if the court does not have any further questions.
Okay, thank you very much. I do have one further question, and this is for the courtroom. You're a law student?
That's correct, Your Honor.
And where are you a law student?
I'm a third-year student at William & Mary Law School.
Okay, thank you very much. And we would like to compliment you on the quality of your presentation. I'll compliment you too, but you do this for a living.
Defense counsel Gallagher argued that by 2016, Ninth Circuit precedent such as Gravelet-Blondin versus Shelton clearly established that an officer violates the Fourth Amendment by employing non-trivial force against a suspect who is neither resisting nor posing a threat. To address the court's concern regarding specificity, Mr. Gallagher invokes the fair warning principle. The Constitution does not require a mirror image case when the violation is a matter of obviousness. Relying on Mendoza versus Block, Mr. Gallagher asserts that the tactical novelty of using a tree as a point of impact does not shield the officer from liability. Furthermore, while the bench noted the minor nature of the physical trauma, Mr. Gallagher maintains that the Fourth Amendment inquiry is not a medical severity test, but a measurement of necessary, and each force degree was necessary. Under the Graham versus Connor, the underlying offense Arizona Revised Statute 13-2412A was a minor regulatory infraction, providing no justification for an escalation to non-trivial force. Ultimately, the evidence suggests the push was an unwarranted act rather than a necessary response to any act of resistance or immediate threat posed by Ms. Mina.
Very quickly, Your Honor. He mentioned Gravela and Meredith, both bystander cases. I just want to make clear. Gravela itself said there's a difference between a bystander and someone who is, quote, integrally involved in the volatile situation to which officers were responding. Meredith.
I'm with you. I agree with you on that. Although, again, I guess I just asked you the question. She's charged with not showing her ID. That seems pretty low on the totem pole. Maybe not a bystander,
Right.
but maybe one step above a bystander.
Sure, but they're investigating possible domestic violence and underage
Well,
drinking.
not from her. Oh,
She's on the median with
no,
Taves.
but I mean, or they suggest. Oh, yeah, I see.
When they go to the median and need to get her off the median, those are the crimes. I would just very quickly, Your Honor, en banc case called Matos v. Agarano that this court has decided, where domestic violence is the volatility of those situations is recognized and the great danger of them is recognized. So this is not just she didn't show ID. There were serious matters to be looked at. I'd also mention just Parker, that Parker only said in 2018 that a shove would not be, there was nothing to say it would be a constitutional violation. Clearly in 2016, that's also the case. So we're always back to this second prong, and that's where we think we win. I will finish with simply saying I also want to compliment my opponent for his argument. We think the evidence, if you look at Mina's testimony, there is no case law that says there was a constitutional violation here that would have put the officer on notice, and we ask that you reverse. And I simply want to say that however uncomfortable I was, I enjoyed our colloquy. Thank you.
Thank you. Thank both sides for their very good arguments. Mina versus Massey, submitted.
Mr. McLaughlin centers the defense on the clearly established prong of the qualified immunity inquiry, asserting that as of 2016, no controlling precedent put the constitutional question beyond debate. To distinguish the bystander precedents of Gravelet-Blondin and Meredith, Mr. McLaughlin argued for a functional distinction. While those cases protect passive observers, they do not extend the same protections to individuals integrally involved in a high-risk investigation. Related to the standard Matos versus Agarano, the defense emphasizes that the volatility of domestic violence and underage drinking scenes increases the government interest in maintaining physical control. By focusing on the tactical necessity of securing a volatile scene, the defense seeks to prove that the officer's actions did not violate a clearly established right defined with the level of specificity required by the Supreme Court. On February 3, 2021, the United States Court of Appeals for the Ninth Circuit issued a formal mandate affirming the denial of Officer Robert Massey's request for qualified immunity. This followed the U.S. Supreme Court's decision on January 11, 2021 to decline intervention in the case, effectively forcing the officer to face trial for the 2016 encounter. Despite this preliminary loss of immunity, the subsequent trial concluded in a victory for the officer. After reviewing the evidence, the jury determined that Officer Massey's use of force was objectively reasonable and did not violate the Fourth Amendment. Consequently, because the jury found the force used during the arrest to be justified under the circumstances, the officer was cleared of liability and Ms. Mina was denied any legal remedy or damages. Following this defeat, Ms. Mina appealed to the Ninth Circuit once more, this time alleging that she had been misrepresented by her attorney during the trial. On July 19, 2024, the Court of Appeals rejected this argument, holding that the constitutional right to effective assistance of counsel does not apply in civil rights actions under 42 U.S.C. 1983. The ruling underscores that while a plaintiff may overcome the hurdle of qualified immunity, the finality of a civil jury verdict cannot be vacated based on the performance of private counsel. So, Officer Massey maintained his defense as the court found no reversible error in the trial's outcome or the jury's verdict. This case presents fundamental questions about the limits of police authority and the scope of Fourth Amendment protections during routine investigative stops. Mr. Gallagher successfully challenged the officer's defense by asserting that his conduct failed to meet the threshold of objective reasonableness. Under the qualified immunity doctrine, an officer is shielded from liability unless their actions violate a clearly established constitutional right. Challenging this immunity is a vital mechanism for ensuring law enforcement accountability. Without it, individuals subjected to non-trivial force, while neither resisting nor attempting to flee, would be left without legal recourse for their injuries. Even though the final jury defined the use as reasonable force, police officers should be held accountable and charged for the ways they interact with citizens. By establishing that, the United States Court of Appeals for the Ninth Circuit showed us that qualified immunity should not be a right to give the officers in every interaction, but an exception to rare occasions. Now, let us know if there is a case you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe for more videos.